I'm Carl Stewart, Chief Judge of the United States Fifth Circuit Court of Appeals. Our court is headquartered in New Orleans, Louisiana, in the John Minor Wisdom Courthouse. I'm very pleased to provide an introduction to a video that has been prepared by the Bar Association of the Fifth Federal Circuit. The overarching goal of our court is to make practice in our court as user-friendly as possible. Our court has federal appellate jurisdiction from all the district courts in 3 states, Texas, Louisiana, and Mississippi. We have over 30,000 active attorneys admitted to practice before our court. Thus, we're very concerned about making the work in the court, whether oral arguments or filings, as user-friendly as possible.
Welcome to the Judge John Minor Wisdom Courthouse, located at 600 Camp Street, across from Lafayette Square. The building was completed in 1914 and has served as the court's home since that time, with the exception of a 10-year period from 1963 to 1973. The court returned to the building after it was renovated in 1973 and has been there since then. The clerk's office is across the street in the Abear building, which is located at 600 South Maestri Street in New Orleans.
The courthouse itself opens at 8 o'clock. Check-in for oral argument is up till 8:30. Please get here on time. When you go through security, you will need your ID. You will also have to take off your belt. You'll also have to put anything else through the usual security routine. And your phone will be put off. Your phone will stay off until you exit the building.
Hi, welcome to the Fifth Circuit.
Thank you. Good
Which
morning.
case are you here for?
Jones versus Jones.
Okay, you Mr. Richard?
Yes, ma'am, I am.
All right, I have you down as the appellant. That's for you, and that's for you. You'll be in the East Courtroom, which is on the 2nd floor, room 223. Take the elevators up, take a right, it's at the very end of the hallway. I have you down, Mr. Richard, as the appellant. 15 minutes to open and 5 for rebuttal.
That's
and you
good.
can proceed to the courtroom.
Thank you very much.
Thank you so much.
Thank you.
All rise. Hear ye, hear ye, hear ye. The United States Court of Appeals for the Fifth Circuit is now open according to law. God save the United States and this honorable court.
The first case on this morning's docket is Jones versus Jones. Mr. Richard?
May it please the court, my name is Don Richard and I represent the appellant in this case.
Counsel is now at the podium, prepared to deliver his oral argument. It's important to stand tall, speak loudly, clearly, and slowly. There are several things on the podium to guide your way. There's both a lighting system and a timing system. While the green light is on, you go. You proceed forward with your argument. But when the amber light in the center comes on, that signals that you have 2 minutes left prior to the end of your argument. And when the red light comes on, it is an absolute stop, even mid-sentence. Your argument is over and you may not continue unless the judges invite you to do so. You'll notice that simultaneously a clock is ticking backwards, telling you how much time you have left to deliver your argument. One final note, if you are the appellant and also delivering a rebuttal argument, the lights will go straight from green to red and you will not get a 2-minute amber warning. At the conclusion of your argument, you may choose to stay and listen to subsequent arguments, or you may choose to leave if you like. We do ask, however, that if you choose to leave at that time while court is still proceeding, please do so quietly. You'll notice that both the entry gate and the doors to the courtroom itself are very large and can swing very loudly, so please use care to close them softly. In addition, once in the hallway, please do not hold a conference with your clients or co-counsel to discuss the case. The judges and the other occupants in the courtroom can still hear you, so you'd be wise to either proceed to one of the attorney lounges or to the Fifth Circuit Bar Association office. If your case is not the first one to be called, you may wait in an attorney lounge. There are 3 identical attorney lounges, one next to each courtroom. You'll notice a numbering system in the lounge itself that tells you which case is presently being argued. When that case moves into the rebuttal phase, that is when the number will flip to the next case number. It's very important, however, not to rely exclusively on this numbering system, as sometimes cases settle or are not argued for another reason. You may have to present your argument sooner than you expected.
I'm Carl Stewart, Chief Judge of the United States Fifth Circuit Court of Appeals. Our court is headquartered in New Orleans, Louisiana, in the John Minor Wisdom Courthouse. I'm very pleased to provide an introduction to a video that has been prepared by the Bar Association of the Fifth Federal Circuit. The overarching goal of our court is to make practice in our court as user-friendly as possible. Our court has federal appellate jurisdiction from all the district courts in 3 states, Texas, Louisiana, and Mississippi. We have over 30,000 active attorneys admitted to practice before our court. Thus, we're very concerned about making the work in the court, whether oral arguments or filings, as user-friendly as possible. The video that's been prepared provides some very helpful information about administrative matters as well as case-related information that should be of great help to a practitioner who's coming to our court. There is a detailed information piece provided by our clerk of court, Lyle, Cayce, and that information from him gives very helpful information in preparing a case. I'm pleased and grateful to the Bar Association of the Fifth Federal Circuit for joining us in an effort to make practice in the Fifth Circuit a comfortable and meaningful experience. I encourage all lawyers, whether they've practiced for a long time or just beginning, to view this video. I have no doubt that they will find very helpful tips in the video. Thank you very much.
Hello, welcome to A Day in the Fifth Circuit. My name is Deborah Pierce, and I'm a governor for the Bar Association of the Fifth Circuit. With me today is Don Richard, who is also a governor for the Bar Association, and Mr. Lyle Cayce, who is the 10th Clerk of Court for the Fifth Circuit Court of Appeals. Before we get started, could you tell us a little bit about this wonderful room we're in here, which serves as a resource for our local practitioners?
Well, we are located on the ground floor of the John Minor Wisdom Building in the court's library, which Judge Wisdom once said himself was the heart of the courthouse. A lot of attorneys who come for oral argument don't visit the library, and I think that's their mistake. In fact, if you're involved in an appeal in this court, the library can be a great resource. If you live here in New Orleans, you can conduct free LexisNexis research, and the librarians are available to help you do research and perhaps even help you write your brief to some extent. And during court week, the library has free coffee. They open at 8 o'clock. They have free Wi-Fi for the attorneys. And perhaps most importantly for those attorneys that are stressing over oral argument, this is a nice, quiet environment to get your composure and put your thoughts together before you have to go upstairs and perform.
Lyle, I know that another resource available to practitioners is the court's website. Could you explain a little bit about that to our practitioners?
The website is located at www.ca5.uscourts.gov, and it has a wealth of information for attorneys practicing in our court. One of the first things an attorney should do when they are involved in an appeal is go to the website and look for that information, because there's a wealth of information there that will be of great assistance to them. Now, when an attorney is preparing for oral argument, it's especially important that the attorney go there and look at several documents. The first of these is a document entitled preparing for oral argument in the Fifth Circuit, and obviously you can see why that would be important. The second one is notice to counsel attending oral argument, and that one also provides valuable information. These are absolutely vital for someone who's going to argue in our court. A third document, which can be accessed from our webpage, but it's actually under the library link, is a document called A Visitor's Guide to the John Minor Wisdom Courthouse. And that document is especially helpful for out-of-town attorneys because it provides information about local lodging, dining, parking facilities, transportation that's available in the area, and other information, including how you can get into the building and get through the checkpoint. I think the bottom line, though, is that attorneys have to visit the website. If they don't, they're making it less likely that their appeal is going to be successful.
Once briefing is complete and it's decided that oral argument will be granted, how does the court schedule the case? How does counsel find out? What can they expect at that time?
Well, let me say first that we, after briefing is completed, send the cases to a 3-judge panel for determination which cases should go to oral argument. Then they return the case file to the clerk's office, and then we schedule the case for oral argument. Normally 6 to 10 weeks before an oral argument setting, we will notify counsel that we are holding an oral argument in their case in a particular week, based upon priorities that the court establishes. For example, a criminal case has a greater priority in terms of expeditious processing the oral argument than a normal civil case. And what's imperative for the counsel to remember is that they must notify us immediately if there's a conflict in their schedule that would preclude them from having that argument that week. We'll work with the counsel to avoid the conflict. We normally can resolve it in a certain number of ways, including letting the counsel have a particular day of that week to have the argument, or even potentially moving the argument to another month if that's absolutely required. But the obligation is on the counsel to quickly review that notice that we send 6 to 10 weeks out and let us know if there's a conflict.
So Lyle, the preliminary notification that's sent to counsel 6 to 10 weeks before the argument does not tell the counsel exactly the date of their argument or the time, nor who the panel is. Is that correct?
No, they do not, because we haven't set those things at that time. However, approximately 5 weeks from the beginning of the oral argument week, we will finalize the calendar and we'll send a notice to the counsel letting them know the location, the date and time of their argument. Bear in mind that arguments sometimes occur outside New Orleans, in Jackson, Mississippi, Houston, Austin, or other cities. Now, it's also important to note that this 5-week notice does not give the identity of the judges. The counsel will find out the identity only 1 week before the beginning of the oral argument week, and we'll post that information on our website, and counsel can go to the website and look under the calendar information, and we'll update and publish the identity of the judges on the panel there. I should also point out that if there's a conflict that arises after we publish the notice and set the calendar 5 weeks before oral argument, the court is extremely reluctant to grant any change in the calendar because it doesn't just affect that case, it affects the other cases that are on the calendar as well. So we will only grant that upon motion of the parties for extremely compelling circumstances, and honestly it's a very rare occurrence where we'll change it absent a death or some serious injury or illness.
Will the clerk keep all attorneys informed as the case draws nearer to argument?
We have a rule that when we send out the 5-week notice, we send it to all parties and attorneys registered in the case. But as you get closer to oral argument, it's much more difficult to keep everyone informed, and so we notify only the lead counsel, which is identified by the parties, and then it's responsibility of that lead counsel to notify all other attorneys or parties on their side of the case of significant events.
Lyle, does counsel have to take any affirmative step when they're notified by your office of the exact date and time and the panel, etc.?
Yes, we will send to the lead counsel in the case a form called an acknowledgement form. And basically this is the form that the attorney who is arguing the case must complete to advise us of certain information. And the lead counsel is responsible for making sure that they pass that, if they're not arguing the case themselves, to the counsel who will argue. And this form provides us necessary information, including the identity of the person who's arguing the case, or if there are more than one, how they will divide up the argument in terms of their time limit, and also whether or not the parties want to save any time for rebuttal. So this is very important acknowledgement that the lead counsel has to make sure is returned to the clerk's office.
And what about exhibits and demonstrative aids? Does the court allow those?
The court strongly disfavors and discourages the use of electronic aids, audiovisual equipment, or exhibits, oversized diagrams and charts, for example. and so we don't like them, bottom line. However, if an attorney absolutely needs to refer to something in the oral argument, the court recommends that they place it on an 8.5 by 11 sheet of paper, for example, a photocopy of the exhibit, which can be given to the judges for their consideration on the bench during the argument. So the bottom line is the court doesn't like exhibits, and if attorneys can prepare their case and argue the case without using them, the court will be pleased.
What about new precedents that might arise post-briefing? How should counsel handle that in front of the court?
Well, Federal Rule of Appellate Procedure 28J covers this and permits the parties to send a letter to the court advising them of the due precedent. And that's the procedure that we use in our court. We have a special rule in our court, however, in terms of the timing of the delivery of that letter. If an attorney files that letter prior to noon on the last business day before the oral argument begins, then our deputy clerks will make the information available to the judges. If it's actually filed after noon, then it's the responsibility of the attorneys that filed the document to make copies of that and to bring them to the oral argument session so that those copies can be given to the judge. And it's also the responsibility of that attorney to give the opposing counsel a copy of the 28J letter.
Finally, we reached the day of argument. Do you have any additional advice for practitioners who are coming in? Should they dress a certain way, or are there certain proprieties that they should observe?
Yes, I'd raise 2 points in that regard. First, you have to dress professionally because you're in a federal appellate court. And for men, that's professional business attire, coat and tie or suit, and for women, comparable professional business attire. And I'd point out that sometimes family members or clients or spectators come with an attorney to court, and those individuals should also dress appropriately, hopefully no less than business casual. That would be acceptable. I would also mention that one little thing that we've noticed in court, that sometimes the counsel refer to our judges as justice. In fact, our judges are judges, and only the Supreme Court has associate justices and a chief justice. So when you're referring to judges, just use the term judge and not justice, and it'll spare yourself a little bit of pain and heartbreak.
Allow those of us who've argued cases in front of the Fifth Circuit often wonder how we did. So how can we hear it? Can we hear it? Is it possible?
Yes, we record oral arguments and we post them on the website between 5 o'clock and 6 o'clock p.m. on the day of oral argument. So if you're really a glutton for punishment and you really want to improve your skills, or you just like to beat yourself up, you certainly can go listen to those arguments. They're readily available.
Lyle, in closing, do you have any additional thoughts or comments you'd like to share with practitioners concerning either the court or the clerk's office itself?
Yes, I'd like to say that the clerk's office is a great resource for appellate attorneys. We take great pride in the fact that we're helping our judges perform their Article III constitutional mission to decide cases, and we recognize that we're the interface with the bar, and we take great pride in the fact that we are available to answer questions from members of the bar, and we'll do whatever we can to assist you. We're not gatekeepers. We don't try to make the lives of appellate attorneys miserable. And quite the opposite. We want to help you as much as we can because that aids in the quick resolution of the case. And I think you'll find my staff is very helpful along those lines.
We'll end our presentation here in the Fifth Circuit Bar Association. You're welcome to stop by before or after argument, or even when you're just in the neighborhood. It's an ideal place to discuss the case with your clients or with co-counsel, either before the argument or simply to decompress after the argument. We also invite you to visit our website, which is www.baffc.org. Thank you, and we hope you enjoyed our presentation.